What? Once she's back, we'll be ready to go. I think that was the old.
I think that was the old one. It's 10:03 now, so 3 hours, you don't know 3.
Should've got this out. Okay, we'll start with appearances. Hey.
Good morning, Your Honor. My name is Will Anderson, and together with my co-counsel, Benjamin Pinto,
Good morning, Your Honor.
and Josie Mastandrea,
Good morning, Your Honor.
we collectively represent the state of Midlands in today's case.
Good morning, Martin.
Good morning, Your Honor. My name is Abigail Adane, and I have the pleasure of being joined by my co-counsel, Miss Olivia Romanson,
Good morning, Your Honor.
and Mr. James Long.
Good morning, Your Honor.
Collectively, we represent the defendant in today's case, Miss Charlie Martin, who will be joined at counsel's table throughout today's proceedings.
Good morning, Your Honor.
Good morning. Any pretrial matters from the state?
Yes, Your Honor. First, the state moves to invoke Rules 603 and 615 of the Midlands Rules of Evidence, the constructive swearing in and sequestration of all witnesses, barring party representatives. Now, the state notes that our party representative in today's case is Investigator Taryn Rivera.
Good morning, Your Honor.
Good morning. Any objection from Martin?
No, Your Honor. We offered Miss Martin as our party representative, Your Honor.
Okay, granted.
Next, Your Honor, the state has prepared a bench book with relevant documents that may help Your Honor throughout today's trial. Defense counsel has seen these documents and approved. Permission from my co-counsel to approach and tender.
Any objection?
No, Your Honor.
Permission granted.
Pretty good, Your Honor.
Thank you.
Next, the state has a few housekeeping matters to ask Your Honor about. First, what are Your Honor's preferences about asking to approach opposing counsel, witnesses, or the bench?
You don't need to ask permission for approaching opposing counsel or your own witness. Please ask permission to approach opposing witness and the bench.
Yes, Your Honor. Next, assuming an objection is sustained, would you like us to move to strike any offending testimony or assume that it is stricken?
Assume that it is stricken if the objection is sustained.
Next, Your Honor, if I could direct your attention to the stipulations tab of that bench book in front of you. Specifically, we're going to be looking at the bottom of the first page, stipulations 10 and 11. Now, the parties have stipulated prior to today's trial that a number of documents have either been pre-admitted or have had objections waived. We will address those documents at the appropriate time, but this is simply to make Your Honor aware of where that stipulation can be found.
Okay, and my understanding is the 4 exhibits listed in stipulation 11 are already admitted into evidence, but the 6 in stipulation 10 still need to be admitted into evidence, but everybody has waived objections to them.
That is correct, Your Honor.
Okay.
Next, if I could direct your attention to the third teal tab of that bench book. This is going to be the orders on motions in limine.
Okay.
Specifically, we're going to be looking at the top of page 4, order C.
Admissibility of interrogations.
Yes. Now, it has been ruled prior to today's trial that the defendant's interrogation may be read onto the record by any party or through a witness without additional foundation at any point once the record is open until the defense team rests their case in chief.
Is that your understanding of the order?
Yes, Your Honor.
Okay.
With that, Your Honor, the state is ready to proceed.
Okay, any pretrial matters from Martin?
Yes, Your Honor. One last inquiry about your preferences. When entering exhibits, do you prefer that we publish to the jury constructively or assume it's been published?
You can assume it's been published.
Next, Your Honor, we'd like to offer a notice of intent to offer character evidence. This has been seen and signed by both counsels. May my co-counsel approach and tender?
Yes, she may. Thank you.
My pleasure.
Okay, so the defendant will offer evidence of peacefulness and forgiveness. Prosecution will offer evidence of prior crimes, wrongs, or acts under 404B. Prosecution will offer evidence of alleged traits of peacefulness to rebut evidence under 404A2C. The defendant will offer opinion or reputation evidence of all state witnesses. And the following parties intend to offer evidence pursuant to Rule 609B, and that is defendant for Lennox Reynolds. Correct?
That
Yes,
is
Your
our
Honor.
understanding.
Next, Your Honor, we'd like to direct the court's attention to 2 relevant sections of the orders on motions limine. That should be the 3rd tab again.
Okay.
You're looking for section E, motions to exclude opinions on Lynn and Job. That should be on page 4. Let me know when you're there.
Okay, I'm there.
Now, this section states that the court finds that Taylor Jaw is an expert in reality TV production, and the prongs of MRE 702A through C have been fulfilled and may not be objected to in today's case.
Okay, and that's, sorry, this is for Dr. Ja?
Taylor Jaw, yes, Your Honor.
Okay, and is Dr. Lin being called today?
Yes, Your Honor. Additionally, that section states that the prongs of MRE 702B and C have been met for Dr. Micah Lin.
Okay, so B and C have been met for Dr. Lin, and A, B, and C have been met for Dr. Ja.
Yes, Your Honor.
Okay, is that your understanding?
That is our understanding.
Next, Your Honor, we'd like to direct the court's attention to section G, legal theories. It should be on the last page. Now, the first paragraph of this states, the defense is permitted to bring forward evidence of mental impairments that prevent Ms. Martin from forming the requisite mens rea of the crime.
Okay,
Along with this, Your Honor, this section states that the defense is permitted to present the theory that Ms. Martin is not guilty of murder, but the lesser offense of negligent homicide. This is the charge the defense will be taking on today.
okay, so the defense is going to be arguing that Martin is guilty of negligent homicide, but not necessarily, or I'm assuming because you're defense, not guilty of the charges.
Yes, Your Honor.
And is the charge murder or manslaughter?
The charge today will be manslaughter, Your Honor.
Okay. Anything further from Martin?
Yes, Your Honor. 2 pieces of Midland's Penal Code that should be on the 5th tab. You're looking at the first page, reckless and negligence. Now, Midland's Penal Code defines reckless as when an individual disregards that their actions could create a substantial and unjustifiable risk. And right below that, Midland's Penal Code defines negligence as when an individual should be aware that their actions could create a substantial and unjustifiable risk, but they fail to perceive it when a reasonable person would.
Okay.
With that, Your Honor, the defense is ready to proceed.
All right, opening statements from the state.
Yes, Your Honor. Chief?
Yes.
Acid in his mask. Water in his lungs. It's April 2025. 34-year-old Rob Armstrong is competing in the final challenge of hit reality TV show The Saboteurs. He's underwater, untying knots, breathing mask securely on. And Rob's a good swimmer. He's done swimming challenges on this show before. He's won this show before. But for some reason, this time's different. Because when he should still have plenty of air left in his tank, Rob begins to struggle underwater. He gets dizzy and disoriented. His throat feels like it's on fire. He's 30 feet underwater and suddenly he can't breathe. And so, panicking, straining for the surface, he whips off his diving mask. And the water rushes in. Afterwards, when investigators start to look into how Rob died, they uncover evidence that recasts an already heartbreaking tragedy into something more than a freak accident. Evidence that points to another contestant on the show. Someone who'd competed against Rob on a previous season. Someone whom Rob had betrayed and humiliated to win the show's $1 million prize. Someone who needed that money bad enough to come back on and do whatever it took to win. The defendant. Charlie Martin. You'll hear today that when the defendant came back to compete against Rob, she swore that this time things would be different. And they were. Because on the morning of April 6th, trying to keep Rob from winning again, the defendant put a toxic substance called oxalic acid in Rob's breathing mask, with deadly results. That is why the state of Midlands is charging Ms. Charlie Martin with manslaughter. Now, you may have heard that term before, manslaughter. But what does it actually mean? Well, Midland's law says that manslaughter is when someone recklessly causes the death of another. So that's what we need to prove to you today beyond a reasonable doubt. Not that the defendant was trying to kill her fellow competitor, just that in putting the acid in the mask, she won. ignored the substantial, unjustifiable risks of her actions, and 2, the risks she took caused Rob to die. So how are we going to prove that to you today? Well, witness after witness will confirm that before the defendant used the acid, she was warned again and again and again about what it could do to someone. But she just didn't listen. And the first witness who will tell you that is Miss Lennox Reynolds. Miss Reynolds is the caretaker and cleaner at the hotel where the show was filmed. And she'll tell you that oxalic acid should only be used for bleaching wood and removing rust. Which is why when she saw the defendant holding a bottle of that chemical, Miss Reynolds told her, that stuff is dangerous. That could hurt or even kill someone. But our next witness, Investigator Taryn Rivera, will describe for you how the defendant ignored that warning and many others. Warnings from the show's production staff, from the safety label on the bottle. Ms. Rivera led the investigation into Rob's death. And she was there when the defendant confessed that despite these warnings, she found Rob's breathing mask that day, picked it up, and hid the acid inside. And folks, the fact that the defendant put the acid in the mask, not up for debate here. Not a single witness you hear from today will deny this fact. So just how exactly did using this toxic chemical end Rob's life? Well, our third witness, Dr. Atlas Hartley, will come up and explain that for you. Dr. Hartley performed the autopsy in this case. He ran the toxicological analysis, and he'll tell you, in no uncertain terms, that the reason Rob died that day was the acid in his mask and the water in his lungs. Members of the jury, the evidence you hear today will prove that Rob's death was avoidable. But instead, the defendant rolled the dice with another player's life, and the results were fatal. And that's why, at the end of today's trial, my co-counsel, Ms. Josie Massandrea, will come up here and ask you to return a verdict of guilty. Thank you.
Thank you, Counselor. Opening for Martin.
Yes, Your Honor. Your Honor, opposing counsel, members of the jury, may it please the court. Everything seemed under control. Just a few moments ago, Mr. Pinto came up here and told you some things we can agree on. It's true. Miss Martin and Mr. Armstrong were rivals. It's true. Miss Martin put a cleaning product in Mr. Armstrong's diving mask. It's true that that cleaning product likely played a role in Mr. Armstrong's death. We agree to all of those things, members of the jury, but it's not the full story. Because what Mr. Pinto didn't even mention was the environment in which these things happen. Because you'll learn today, all of that happened on a TV show set called The Saboteurs. An environment that placed contestants in situations that couldn't be further from reality. And last April, Miss Martin was one of those contestants. She was placed in an environment that allowed her to do some things you and I sitting in this courtroom may consider dangerous. Contestants had to walk on a tightrope between two tall buildings, lie in a coffin filled with snakes, and be buried alive for 20 minutes. But you'll hear, that danger, well, it was a part of the game. So during that final challenge, Miss Martin did exactly what she had done for an entire season. She sabotaged her biggest opponent, Mr. Armstrong. But then, Mr. Armstrong died. A tragedy no one could have seen coming, including Miss Martin. Because you'll hear the saboteurs, it's not just this show. It's a controlled environment. Every challenge was planned. Every risk was managed. Every contestant was protected by strict safety standards. So that constant reassurance of safety, it caused Miss Martin to develop a false sense of security. To her, everything seemed under control. Now that's a problem for the state, because they must prove to you beyond a reasonable doubt two elements: that Miss Martin's actions are what caused the death of Mr. Armstrong, and that she ignored a substantial risk while doing so. Members of the jury, I want you to focus on that second element throughout today's trial, because what differentiates between manslaughter and the lesser crime of negligent homicide is whether someone understands consequences. That mindset is gonna matter today, because manslaughter, it's more than just a person's actions. So throughout today's trial, we'll ask you to consider three questions. What was the environment like on the saboteurs? Did Miss Martin believe sabotages could be harmful? And why? Did Miss Martin think her actions were okay? We'll answer that first question with Taylor John, an expert in reality TV. He'll tell you how every aspect of the saboteurs was planned. He'll explain that the dangerous nature of the show was consistently controlled by safety precautions. Then, you'll hear from Ms. Martin herself. She'll answer that second question for you. She'll tell you how she believed that the show's safety precautions would prevent any real harm from happening. Because for 10 seasons, that's what she saw. That's what she was taught. Because that's what she expected. And then finally, we'll ask you to consider why Miss Martin thought her actions were okay. With Dr. Michael Lin, a clinical psychologist, he'll tell you that Miss Martin developed a false sense of security because of the constant reassurance of safety on the show. Members of the jury, the state wants you to focus on only half the story, on simply what happened. We are asking you to go beyond that and focus on what Miss Martin believed. She believed that every challenge, every sabotage, every action would be safe. Because that's exactly what 10 seasons had proven to her. To Miss Martin, everything seemed under control. And that's why, at the end of today's trial, my co-counsel, Mr. Long, will come before you and ask for the only verdict the evidence will support. Not guilty. Thank you.
Thank you, Counselor. Is the state ready to call its first witness?
Yes, Your Honor. The state calls Miss Lennox Reynolds. Actually,
Yes, you may.
good morning.
Good morning.
Could you please introduce yourself to the jury?
Hi, my name is Lennox Reynolds.
What do you do for a living, Miss Reynolds?
I'm a caretaker at B Hotel Lux, which is Midland's most popular wedding destination and recent host of hit reality TV show, The Saboteurs.
To your knowledge, what is the Saboteurs?
I'm more of a sitcom girl personally, but from what I know, just like being around the Saboteurs, is that it's this super competitive game show where contestants will come and play games against each other, and then there's people who sabotage each other, and there's like $1 million grand prize. It's supposed to be super messy.
While they were filming at the hotel where you work, what exactly was your role?
My main job was to clean contestants' rooms. I know, super glamorous, but honestly, it's really fun because you find the weirdest things in there. Like, okay, one time, we found this entire collection of antique bobbleheads.
Miss Reynolds, do you know Charlie Martin?
Oh my gosh, yes, I love Charlie. We met like, gosh, what is it, 5 years ago now when she first came to the hotel. And then like she's come back a couple times every year and we play board games every time. It's so much fun.
Miss Reynolds, do you see her in the courtroom right now?
Yeah, she's right over there in the, I think it's navy suit, I'm not sure, but it looks really good.
Your Honor, let the record reflect that Miss Reynolds has accurately identified the defendant.
Okay.
Miss Reynolds, did the defendant ever tell you if she was on the show, The Saboteurs?
Yeah, so Charlie told me that she was initially on season 2 of the show, but was eliminated right before the season ended.
Did she say how she was eliminated?
Oh my gosh, yeah. She told me how there's this guy named Rob Armstrong, and apparently in the beginning of the season, they were like super close. But then Rob betrayed Charlie in the second to last episode and humiliated her on national television.
Did the defendant mention Rob Armstrong a lot?
Oh yeah, Charlie talked about Rob all the time. I mean, one time she even told me that Rob ruined her life and that she doesn't know if she'll ever get over that.
Did she say how Rob ruined her life?
Yeah, so after season 2 ended, Charlie and I talked a lot about the brutal comments she was receiving online. I mean, there were videos, tweets, emails, like really, who sends hate emails? But all of it put her in therapy for quite a long time, and that's not even considering what happened to her mom.
What happened to the defendant's mom, did she say?
Yeah, Charlie told me that people started mocking her in public too. So much so that she lost her job and suffered a stress-induced heart attack.
Miss Reynolds, earlier you mentioned that you would clean contestants' rooms during that season. Did you ever clean the defendant's room?
Yeah, so when Charlie came back to the show for season 10, I of course cleaned her room.
Did you find anything in there that was notable for you?
Yeah, there were used gloves and face masks everywhere, along with a bottle of oxalic acid.
Okay, well, to your knowledge, what exactly is oxalic acid?
It's this industrial cleaner that I use for like rust removal and bleaching hardwood floors, but it's super dangerous. I mean, whenever I use it, I always use my protective gear. The hotel gives us monogrammed ones, it's kind of fun. And I make sure to use the 1 gram scoop that comes with the bottle.
Exactly when did you find this oxalic acid in the defendant's room?
About a week before Rob Armstrong died.
And Ms. Reynolds, during the filming of that season, did you ever see the defendant actually with this oxalic acid?
Yeah, I did. So around that same time, I found Charlie and this other contestant, Nell, I think, in the basement with the acid, which was super weird because they're not allowed to have that acid. And they're definitely not allowed in the hotel basement. I mean, rules are very clear. It is for staff only because A, it's haunted, and B, it's a liability issue.
Well then, Ms. Reynolds, do you know what she was doing down there?
No, not really. I heard her say something about getting food, but we don't keep food down there.
When you saw the defendant with this chemical, did you say anything to her?
Well, yeah, I kind of jumped at them and said that this stuff is super dangerous and could hurt and possibly even kill
Objection,
someone.
Your Honor, to hearsay. This is an out-of-court statement being used for the truth of the matter asserted.
Response, Your Honor.
Yes.
We're not using this statement for the truth of the matter asserted. We've already heard that it's dangerous from other testimony. Rather, we're using it to prove an effect on the listener. It's our contention today that the defendant was warned about the dangers of oxalic acid and then proceeded to ignore those warnings.
Response, Your Honor?
Yes.
Yes, Your Honor, this is absolutely being used for the truth of the matter asserted. It's prosecution's contention. Like they said, that her ignoring these dangers is what led to her putting it in the mask and then eventually killing Rob Armstrong. They're contending today that that oxalic acid was dangerous enough to have killed Rob Armstrong. They are definitely using this for the truth of the matter.
Are you contesting that the oxalic acid is dangerous?
Yes, Your Honor.
Did this witness already testify to it being dangerous?
Yes, Your Honor.
Okay, so since we already have the testimony that it's dangerous from her, aside from these statements, I'm gonna admit it just for whether the defendant heard from her that in her opinion, it's dangerous. And we can, you're free to contest on cross or with a different witness whether it's actually dangerous.
Yes, Your Honor.
So the objection is overruled.
Yes, Your Honor. Ms. Reynolds, what exactly did you say to the defendant when you saw her with that oxalic acid?
I told her that it could hurt or possibly even kill somebody.
Given the safety procedures that you follow, did you ever hear producers talk with the defendant about safety at all?
Yeah, I overheard them in a safety discussion about a sabotage that Charlie wanted to implement.
What sabotage did the defendant want to propose?
She asked to put rat poison in Rob's food.
Ms. Reynolds, what did the producer say to putting rat poison in Rob's food?
He said, absolutely not, that's not allowed. That could really hurt somebody.
Thank you, Ms. Reynolds. Nothing further, Your Honor.
Thank you, Counselor. Cross-examination?
Yes, Your Honor. Good morning, Ms. Reynolds.
Good morning.
Now, this isn't your first time being in court today, is it?
No, it's not.
You actually testified for your child a few years back,
Yeah, 12 years ago now?
and during that trial, you put your hand on a Bible,
Yeah,
and you swore to tell the truth and nothing but the truth.
I was under oath.
You talked to a jury just like this one,
Yes.
and Ms. Reynolds, you lied.
Objection, Your Honor. Under Rule 403, this is more prejudicial than probative. Specifically, could I direct your attention to Rule 609B, Midland's Rules of Evidence, should be that light orange tab. Simply put, Your Honor, there is a limit on using convictions that are more than 10 years old. It's our understanding today that this conviction occurred 11 years ago, and so this sort of line of questioning is impermissible.
Response, Your Honor.
Specifically, page 7. Apologies, sir.
Give me one. You're objecting under 403, more prejudicial than probative, or?
Pardon me, Your Honor, improper evidence of criminal conviction. That'd be more accurate.
Under?
So, yeah, 609B, Your Honor, which is on page 7.
Okay. Okay. 609B. Response?
Yes, Your Honor. 609B actually also states that a criminal conviction of after 10 years is admissible as long as the probative value substantially outweighs that prejudicial value. Given that Ms. Reynolds is under that same oath of perjury today, this is incredibly probative in today's case.
Okay, from my understanding, we haven't heard anything about a criminal conviction yet, have we?
If I may make an offer of proof,
Sure.
I'm going to point out how she was convicted of perjury.
And that specifically is what you're concerned about?
Yes, Your Honor.
I mean, it seems pretty probative that a witness has been convicted of perjury before, right?
Yes, Your Honor. However, you'll note that it is a high bar, substantially more probative than prejudicial. And secondly, the circumstances of this case are very different. And as you'll see, circumstances are very important in meeting this bar. It's our understanding that Ms. Reynolds was testifying for a defendant in a criminal trial 11 years ago, and now she's testifying for the prosecution. So these circumstances are substantially dissimilar, which means that they can't meet this bar.
Response, Your Honor?
Yes.
These circumstances are not different in that she's subject to that same oath. She put her hand on a Bible, she swore to tell the truth just like she did 11 years ago. She's under those same rules, she violated them 11 years ago, making this substantially more probative than prejudicial.
Okay, I'm going to allow you to ask her if she committed perjury.
Yes.
I'm gonna ask that you not bring up any specific conviction unless she does not admit that she perjured herself in the past.
Yes, Your Honor.
Would I be able to re-raise my objection at this time? Apologies. After she asked that question, or sort of
I mean,
past
if
that moment?
you can re-raise your objection if she asks about a specific conviction, but to the extent that she's asking if this witness committed perjury, I'm going to overrule the objection and allow an inquiry into whether this witness has committed perjury.
Understood, Your Honor.
Yes, Your Honor. Ms. Reynolds, just to make it clear, you lied under oath.
So about 12 years ago, my son had the great idea to rob a convenience store with his friends. And so when I was called in to testify, I told the jury that he was with me. And that wasn't true, but I've learned my lesson from that.
So that's a yes to my question, Ms. Reynolds. You lied under oath.
For my kid, yeah.
Ms. Reynolds, let's talk about what you just discussed on direct examination. You're one of the cleaners for the Hotel Lux,
Yes.
and you cleaned Miss Martin's room.
Yes, along with all the other contestants' rooms.
And you said you found a bottle of oxalic acid.
Yes, I did.
Ms. Reynolds, just to make it clear, you don't know how that bottle got there.
No, I have no idea.
You don't know why Miss Martin had it.
No, it was weird that the chemical was in her room.
You don't know who could have put it there.
I mean, I assume it was Charlie, but I don't know.
Ms. Reynolds, all you know is that you saw it one time when cleaning Miss Martin's room.
Yeah.
Now, let's talk about that other time you saw Miss Martin in the basement of the Hotel Lux.
Yes,
Now, you said you saw oxalic acid there,
I did.
and you warned her and the other contestant about the dangers of it.
Oh yeah, I even made sure to emphasize that they shouldn't breathe this stuff in.
Ms. Reynolds, that's a yes to my question. You warned them about it.
Yeah.
But when you warned them about it, Miss Martin wasn't the one holding the oxalic acid, was she?
No, Nell was holding it, and they kind of jumped. I'm yelling.
Ms. Reynolds, you actually saw Miss Martin take the bottle of acid and put it right back on the shelf.
Well, yeah, after I told them, hey guys, shouldn't be here, shouldn't be with the acid, she just took the bottle, looked at it, put it back on the shelf.
That's a yes to my question. She just put it right back.
Well, yeah.
Now, Ms. Reynolds, you just told us on direct that you've known Miss Martin for 5 years.
Yeah.
She's a frequent guest at the Hotel Lux.
Oh, yeah, Charlie comes a couple times a year. It's so much fun.
You've talked to her very often.
Yeah,
And you saw season 2 of The Saboteurs.
I did.
And you know that Miss Martin was quite bullied online because of season 2.
It was brutal.
But, Ms. Reynolds, you believe that Miss Martin is the kind of person to turn the other cheek.
In my experiences with her, yes.
Now, Ms. Reynolds, let's talk about the last time you saw Miss Martin. This was the day after Mr. Armstrong died.
Yeah,
Ms. Reynolds, it looked like she'd been crying.
it did. I was cleaning her room, about to leave, and that's when she walked in.
Ms. Reynolds, she looked at you and she said she didn't mean to hurt anybody.
Objection, Your Honor. They're hearsay.
Response, Your Honor?
Go ahead.
Yes, Your Honor. This falls under a hearsay exception, 8033, in particular intent. This was Miss Martin expressing her intent to not want to hurt anybody.
Response?
Yes, Your Honor. Well, this is a backwards-looking statement. Ms. Martin, if she made this statement, was talking about events that occurred in the past, which means that she can't be talking about her present mental, emotional, or physical state.
Can't be talking about her.
Sort of then existing.
Can't be talking about her then existing state of mind for something that already happened.
Yes, Your Honor. Or she can't describe what she intended in the past and still have that count as her then existing mental state. Is our argument here.
Response, Your Honor?
I don't think there's a need. I'm gonna overrule the objection and allow this testimony.
Yes, Your Honor. Ms. Reynolds, I'm gonna ask you one more time. She looked at you and she said she didn't mean to hurt anybody.
That's what she told me, yeah.
Thank you, Ms. Reynolds. No further questions, Your Honor.
Thank you. Anything on redirect?
No, Your Honor. We just asked that Ms. Reynolds be excused.
You may be excused. Thank you for your testimony.
Thank you.
Next witness for the state.
Yes, Your Honor. At this time, the state calls Ms. Taryn Rivera to the stand. Can I proceed?
Yes. Yes, you may.
Please introduce yourself to the jury.
Good morning. My name is Tara Rivera.
Ms. Rivera, what is it that you do for a living?
Well, I'm coming up on my second year doing undercover work with the Federal Trade Commission. And before that, I did about 10 years at the FBI, where I led multiple homicide investigations.
Now, is working with the FTC how you came to be involved in today's case?
It is. The FTC had received a number of tips that this show called The Saboteurs was being rigged. So they sent me out there to investigate.
What did that assignment have you do?
Essentially, I was asked to go undercover as one of the production crew members. For about 8 weeks, we lived and worked at the Hotel Lux in Charlotte County, Midlands. Obviously, I couldn't see my kids for that amount of time, but it's a part of the job.
So how did that investigation end?
It didn't end, per se, as much as it changed into a murder investigation after someone died on April 6th, 2025.
Who died on April 6th?
Rob Armstrong. He was a contestant on the show.
At that point, what was the next step in your investigation?
Well, we were able to make an arrest at the end of the collection of evidence.
Who was arrested?
The defendant, Charlie Martin, was arrested on June 2nd, 2025.
What did you do after the defendant was arrested on June 2nd?
Well, that very same day, we brought Miss Martin in for a formal interrogation.
Were you present for that interrogation?
I was.
Would you recognize a transcript of that interrogation if I were to show it to you in court today?
Absolutely.
Your Honor, let the record reflect I'm approaching opposing counsel and the witness with what has been pre-marked as Exhibit 7. Courtesy copy for the bench.
Yes. Thank you.
Ms. Rivera, what have I just handed you?
Well, this is a transcript of the interrogation we gave Miss Martin.
Is it a fair and accurate copy?
It appears to be, yes.
Has it been changed or altered in any way?
Not at all.
Your Honor, at this time the state offers Exhibit 7 into evidence.
Yes, Your Honor. Objection at this time to hearsay to this document, if I may be heard.
Yes.
Your Honor, the defense has no problem with admitting any of the statements of Ms. Martin. However, this document also contains statements of the interrogating officer. We contend that those are out-of-court statements being used for the truth of the matter asserted.
Response?
Yes, Your Honor. The statements by the officer in this interrogation are mostly questions, which do not hold inherent truth value. Now, to the extent that there are assertions of fact by the officer in that interrogation, the state is amenable to a limiting instruction to the jury that those statements specifically not be taken for the truth of the matter asserted.
Because of the court's prior ruling, I'm going to allow you to point to specific statements here and to question her about them, and we can take piece by piece. Objections in terms of whether to admit the whole thing, I'm going to reserve that question right now, and we can get back to it later if you feel you need the entire document admitted, but to the extent right now you want to use it for specific questions or areas, let's take that one at a time. Is that okay with both parties?
Yes, Your Honor, and we would be even amenable to the limiting instruction on the officer's statements.
Okay. Then,
For them not to be taken for any of their truth value, just to be used for
Oh.
for the context of Ms. Martin's answers or something like that. We're amenable to instructing the jury that those officer statements won't be used for their truth.
Okay. I will take that into account when we come back to this.
Yes, Your Honor.
Yes,
Thank you
Your
both.
Honor. So, Ms. Rivera, what happened during this interrogation?
Well, at first, Miss Martin told us that she only came on the show because she needed money to repay her debt. But after some more questioning, she admitted to putting a chemical called oxalic acid into Rob Armstrong's respirator. After that, she swore up and down that she thought this was within the rules of the game.
Did that statement by the defendant contradict your investigation?
It did. The other evidence we've collected made it difficult to believe that Miss Martin thought this was a permissible sabotage.
Objection, Your Honor. At this time, there's a lack of foundation, if I may be heard.
Yes.
Yes, Your Honor. Ms. Rivera just made a conclusion about how what she heard from Ms. Martin was different from the evidence that she collected. We just asked that evidence, the processes she took, the evidence she collected, those things be laid onto the record so that the jury can understand how there's a contradiction there. As of right now, to say that Ms. Martin's statements contradict the evidence that she found in a broad sense like that, there's a lack of foundation on the record as to how that's the case.
Response?
Your Honor, Ms. Rivera is testifying within her rationally based perception about the evidence that she saw and how that contradicted to what she heard within the interrogation. Now, as for opposing counsel's specific objection there, the foundation will be laid in the next questions. I ask for a conditional admittance to that statement, just until that foundation can be laid.
I'm going to sustain the objection and ask that you ask for that conclusion after we're able to hear the evidence.
Yes, Your Honor.
Yes, Your Honor.
Now, what evidence did you recover that contradicted the defendant's claims?
During the course of our investigation, we discovered a number of documents. One of these actually detailed the rules and regulations for contestants on the show.
Would you recognize that document if I were to show it to you in court today?
I would.
Your Honor, let the record reflect, I'm approaching opposing counsel and the witness with what has been pre-marked as Exhibit 33. Courtesy copy for the bench.
Yes. Thank you.
Mr. Rivera, what about you stand here?
This is one of the safety documents we found during our investigation.
Is it a fair and accurate copy?
It is.
Your Honor, at this time, the state moves Exhibit 33 into evidence.
Any objection?
Yes, Your Honor, this time it's a hearsay.
Response?
Yes, Your Honor. This statement is not hearsay, as it comes in under Rule 801D2B, a party opponent statement that was adopted by the defendant. As you'll see at the bottom of this document, the defendant signed it with her signature. Now, in doing so, she acknowledged the statements on this document and adopted them as her own.
By signing below, I acknowledge that I have read and understand these safety restrictions, and I understand that sabotage does not include conduct creating a substantial risk of serious bodily injury. And you're saying that that means she adopts the entirety of the statement, and that that signature is not just saying that she's read and understand them?
Your Honor, specifically, that statement that you just read talks about substantial risk of bodily injury. That calls directly to the limits of sabotage and prohibited conduct, which also discuss the substantial risk to bodily injury. Now, this document further is not being offered for the truth of the matter asserted, rather for the defendant's knowledge in this case. As they signed this document, they understand what could cause, what could count as bodily injury, and what could cause that bodily injury. Thus, we're not interested in the truth of the matter asserted that these were indeed the rules of the game, but that the defendant had knowledge of what substantial risk of bodily injury was, and that they consciously disregarded those warnings and recklessly caused the death of Mr. Armstrong.
So you're arguing that it's not hearsay under 801D2B, and that alternatively it's not hearsay because it's not being offered for the truth of the
Yes,
matter.
Your Honor.
Response?
Yes, Your Honor. Defense is amenable to a limiting instruction that the contents of this document, with the exception of that statement at the bottom that was adopted by Ms. Martin, starting with by signing below, that all of that would be not taken for its truth value with regards to whether or not those were the rules on the saboteurs, and then we understand the ruling on that being Ms. Martin's statement that she adopted, but simply that last paragraph falling under 801 DB.
Is serious bodily injury a legal question for us, or is it one that these rules dictate for the jury?
For the defendant to have recklessly killed Mr. Armstrong, she would have to have knowledge of the potential causes of serious bodily injury and what that means in order to consciously disregard those substantial warnings and cause that death.
Yeah, but what the saboteurs consider serious bodily injury is not what the jury needs to consider serious bodily injury, correct?
Yes, Your Honor, but the specific points in this document discuss poisoning. Now, the fact that the defendant had that knowledge, that could cause serious bodily injury, is substantially probative in today's case.
Okay, I'm going to admit the exhibit only to the extent that Charlie Martin understood that sabotage does not include creating a substantial risk of serious bodily injury, and I am not going to admit any other part of the exhibit.
Yes, Your Honor.
So to that extent, the objection is sustained.
So, Mr. Rivera, what exactly does this document say?
Well, when we look at the bottom section, labeled prohibited conduct, it clearly states that any sabotage that involves tampering with...
Excuse me, yeah.
Objection, Your Honor, to facts not in evidence. We just ask, pursuant to your prior ruling, that those not be read onto the record because they're not in evidence.
Response?
Your Honor, I believe your ruling was that you admitted the document pursuant to the defendant's knowledge in this case.
Sorry, I admitted the document mostly for this last paragraph, that the defendant understood that sabotage does not include conduct creating a substantial risk of serious bodily injury. But I am not admitting the portions above that paragraph that goes on with what the saboteurs considers to be serious bodily injury or prohibited conduct.
Just a clarifying question there, Your Honor. Opposing counsel suggested a limiting instruction to the members of the jury. Are you saying this is going to be constructively redacted, or that limiting instruction is going to be?
I'm going to constructively redact.
Yes, Your Honor.
Yes, Your Honor.
So, Ms. Rivera, how did the information in this document affect your investigation?
Well, in her interrogation, Ms. Martin told us that she read every word of this document before signing. And looking at that limits of sabotage section, some of the symptoms just didn't align with what she had told us in her interrogation.
Objection, Your Honor. Once again, to facts not in evidence. The reference to the limits of sabotage section that has been constructively redacted pursuant to your prior rule.
Response?
Your Honor, Ms. Rivera did not lay any of the words on this document into the record. She is simply describing what she saw from this document and how that contradicted from what she heard within the defendant's interrogation.
Okay, I'm going to allow the testimony and instruct the jury that the limits of sabotage are those that Charlie Martin adopted, which is that sabotage does not include conduct creating a substantial risk of serious bodily injury.
Yes, Your Honor.
So
Yes,
to
Your
that
Honor.
extent, the objection is overruled.
Yes, Your Honor.
Yes, sir. Now, Ms. Rivera, do you know how the defendant may have gained access to oxalic acid while competing in the All-Star season?
I did. Because I had been on set since January, I knew that there were bottles of oxalic acid in the basement of the hotel. And when we spoke to Ms. Reynolds, she told us that she had seen a bottle of oxalic acid in the defendant's room.
Would you recognize a label to that bottle if I were to show it to you and quote to that?
Absolutely.
Your Honor, let the record reflect on approaching opposing counsel and witness, which has been pre-marked as Exhibit 13. Here's a copy for the bench.
Yes, thank you.
Ms. Rivera, what have I just handed you?
This is the label that was on the bottle of oxalic acid from the hotel.
Is it a fair and accurate copy?
It is.
Has it been changed or altered in any way?
Not at all.
Your Honor, at this time, the state moves Exhibit 13 into evidence, which all objections have been waived to pursuant to the stipulation.
Is that your understanding of the stipulation?
Yes, Your Honor. We would just like to direct the court's attention as well to Stipulation 25, which states that the parties agree that when printed and laid flat, the label contained in this exhibit measures 7.5 by 3 inches.
Okay. Do these look like 7.5 by 3 inches?
I'm not exactly sure of the size
Okay.
of that print, so just to lay that onto the record that would have been the size of the label.
Is that your understanding? of the
Yes, Your Honor,
stipulation?
that is our understanding.
All right, sounds good. It's in there.
Ms. Rivera, what does this document say?
Well, looking at the second page, this document says that oxalic acid could be fatal at high concentrations. And right above that, in big, bold letters, the label warns that the product is corrosive, toxic, and just overall harmful if inhaled.
Now, did the document say anything specifically that affected your investigation?
Actually, it did. Towards the bottom of this page, the label says that oxalic acid should be diluted to the desired strength. And to help with that, the product comes with a 1 gram scoop.
How did the mention of a scoop affect your investigation?
When we arrested Miss Martin and searched her home, we found a 1 gram scoop in her backpack. After running some tests, we discovered that that scoop had trace amounts of oxalic acid residue.
Would you recognize that scoop if I were to show it to you in court today?
Yes.
Your Honor, let the record reflect. I'm approaching opposing counsel and the witness with what has been pre-marked as Exhibit 32. Ms. Rivera, what have I just handed you?
This is the scoop that we found in the defendant's backpack in her home.
And is it substantially the same as when you saw it in the defendant's home?
It is.
Your Honor, at this time, the state moves Exhibit 32 into evidence.
No objection, Your Honor.
Admitted.
Did you mention the discovery of this scoop to the defendant during her interrogation?
We did. In fact, when we showed it to her, she was clearly taken aback. She was confused as to where we had even found the scoop. So naturally, we kept asking questions, until the defendant admitted to putting 2 or 3 scoops into the victim's mask.
Thank you, Ms. Rivera. And thank you, Your Honor. I have no further questions. Let the record reflect I'm approaching to retrieve the documents. And permission to tender Exhibit 32.
Commissioners. Cross on the state.
Yes, Your Honor.
Sorry, from Martin.
Yes, Your Honor. Permission to proceed.
Yes.
Good morning, Ms. Rivera.
Good morning.
I want to talk a little bit about the investigation you conducted.
Absolutely.
Because as part of your investigation, you searched the hotel where the show was being filmed, right?
I did collect evidence from the hotel.
But Ms. Rivera, that search didn't occur on April 6th, the day that Mr. Armstrong died, did it?
No, it didn't.
And that search didn't occur on April 7th, the day after he died, did it?
It did not, no, but it still occurred nonetheless.
Mr. Rivera, you would agree that you didn't conduct that search until several days after Mr. Armstrong died.
That is true.
And by that point, when you conducted the search, all the contestants had gone home from the hotel.
They had. We had interviewed the contestants that we needed to.
But by that point, the producers and the crew had gone home from the hotel as well.
They had gone home, but once again, we were able to make arrests and interview contestants and producers as needed.
But Mr. Rivera, by the time you conducted that investigation, the set of the saboteurs had been deconstructed.
Mostly, yes.
And by the time you conducted that search of the hotel, all of the rooms had been thoroughly cleaned. Is that right?
That is true, yes.
And as a result, you didn't find much physical evidence in the hotel, did you?
We didn't, but that's not to say we didn't find much physical evidence at all.
But despite all of that, Mr. Rivera, you're confident enough in what you did find to come to a conclusion about today's case.
Absolutely. We got a confession from Ms. Martin, as well as finding the scoop with traces of oxalic acid.
Well, I want to talk about Ms. Martin's interrogation, because as you mentioned on direct examination, you were present that day, right?
I was.
And you told the jury about how Ms. Martin told police officers that she put oxalic acid in Mr. Armstrong's diving mask. Is that right?
That's what she told us, yes.
But you didn't tell the members of the jury what Ms. Martin was thinking when she made that decision.
Ms. Martin didn't tell us what she was thinking, she only told us what she did.
It's not a true investigator. She told you exactly what she was thinking in that interrogation, didn't she?
I'm not sure what you mean.
She told you that she didn't think Mr. Armstrong would even put the mask on in the first place, right?
That's what she told us, but, well, good investigative work is kind of like parenting. You know, my daughter can tell me that it was my husband who colored on the wall instead of her, but you follow the evidence, not the story.
Mr. Bear, I'm not asking you to make any assumptions about the evidence you found. I'm asking you about what Ms. Martin told you. She told you she thought Mr. Armstrong wouldn't put that mask on.
That's the story she told us, yes.
She also told you that she thought he would smell the oxalic acid and put the mask down.
That's the story she told us.
She told you that it was never her intention to get anybody hurt.
Again, yes.
Now, you also talked about the scoop that you found in Ms. Martin's home, is that right?
I did.
He told us that she admitted to you that she put 2 to 3 scoops in his mask?
That's what she told us.
But these weren't full scoops, were they? These weren't 1 gram scoops.
Well, the first scoop was a full 1 gram scoop, and then she told us that she did add 2 or 3 that weren't technically full.
That's right. Those later scoops were much smaller. She told you that.
Then the full first scoop, yes.
All right. Investigator Rivera, despite Ms. Martin telling you what she was thinking when Mr. Armstrong, when she put oxalic acid in Mr. Armstrong's mask, you didn't look into her mindset with any other part of your investigation, did you?
No, I've learned to follow the evidence more so than the story.
Well, in following the evidence, you stayed focused only on Ms. Martin's actions. Is that right?
As well as her confession to putting the acid in the mask.
But just to clarify, investigator, you focused on her actions, not her mindset. Is that right?
Her actions and what she told us, yes.
No further questions, Your Honor.
Anything further from the state with this witness?
No redirect, Your Honor. I just ask that Ms. Rivera be allowed to step down, please.
You can be excused. Anything further from the state?
Yes, Your Honor. The state calls Atlas Hartley to the stand. Would my co-counsel be permitted to construct a visual aid in the well?
Yes.
Your Honor, permission to move around while the seat.
Yes.
May I proceed, Your Honor?
Once defense counsel has a chance to be able to get somewhere where she can see the demonstrative, then you can proceed. Go ahead.
Please introduce yourself to the jury.
Good morning, my name is Atlas Hartley.
What do you do for a living?
I'm the chief medical examiner for Charlotte County Midlands.
Could you tell us a little bit about your educational background?
Sure thing. I got my undergraduate degree in forensic science from the University of Central Florida. Then I went down to the University of South Florida. Big change, I know. But that's where I got my medical degree.
Are you board certified?
Sure am, in forensic pathology as well as controlled substance and toxicology profiling.
And what does your work in the medical field look like?
Oh gosh, I've been in this field for coming up on about 2 decades now, and a bit of a unique line of work, I'll admit, but for me, every autopsy is really about filling in the blank in the last chapter of someone's story. And that's why I'm proud to say that I've helped provide those answers in over 6,000 cases during my career.
Dr. Hartley, how are you involved in today's case?
One of the autopsies that I performed was of Mr. Rob Armstrong, allowing me to form a conclusion as to his cause of death.
And what materials did you review in coming to that conclusion?
There was, of course, my autopsy of his body, as well as a review of some dive footage taken of him immediately prior to his passing.
Were these materials sufficient?
Yes, they were.
What method did you use in your analysis?
I employed the CORE method.
What's that?
Oh, sorry. CORE is an acronym, so C stands for conduct the autopsy, O for observe, R for review the evidence, and E for evaluate the findings.
Is this method reliable?
Yeah, it's the gold standard in the field.
Were you able to reliably apply it to the facts and data you reviewed?
Of course, as always.
So, Dr. Hartley, what was your opinion regarding Rob Armstrong's cause of death?
I concluded that Mr. Armstrong's ultimate cause of death was drowning, but that was really just the tip of the iceberg. And there was more work beneath the surface.
What do you mean?
During the course of my autopsy, I actually discovered that his drowning was induced by oxalic acid poisoning.
Would you recognize that autopsy if I were to show it to you in court today?
Certainly.
Let the record reflect I am showing opposing counsel exhibit 3 and approaching the minutes.
Thank you.
Do you recognize what I just handed you?
Yes, I do. This is my report on the autopsy I conducted of Mr. Armstrong.
Does it look to be fair and accurate?
Yeah, it does.
Has it been changed or altered in any way since you last saw it?
No, it hasn't.
And was it regular for you to make this kind of report?
Yeah, I typed this up as soon as I was finished with my analysis, and then filed it away according to standard procedure at our office. Same with any report.
Your Honor, I now move to enter exhibit 3 in evidence.
Any objection?
No objections at this time.
Submitted.
Your Honor, permission to approach the bench with a copy.
Permission granted. Thank you.
So, Dr. Hartley, how did your examination begin?
Like I note here in my report, I conducted a visual observance of the body, and that included the brain, where I actually noticed a little bit of swelling, which indicated it wasn't getting enough oxygen immediately prior to his passing.
Do you know what was causing that to happen?
Yeah, thanks to the toxicology results that I reviewed, that I wrote out down here, I discovered the culprit was oxalic acid poisoning.
Your Honor, permission to, let the record reflect I'm retrieving document witness. Now, could you tell us a little bit about what oxalic acid actually is?
Oxalic acid, it's a chemical that's used in some pretty potent cleaning solutions, oftentimes to bleach wood.
Is it dangerous?
Extremely. But the label on a bottle of oxalic acid would lay out those dangers for anybody who read it. As a matter of fact, I did actually bring a bottle, or excuse me, an enlarged version of that label to help explain some of those warnings for the jury.
Your Honor, permission to display the visual aid at this time.
Any objection? Have you seen this visual aid?
Yes, Your Honor, no objection at this time.
Alright, permission granted.
And permission for the witness to step down to make use of it.
Sure.
So, Dr. Hartley, what is this?
This is a blown up version of that warning label from a bottle of oxalic acid.
What warnings does it include?
Well, for one thing, if you so much as breathe in some specks of dust, we're talking coughing, choking, chest pain, even lung injury.
And what if you breathe in more than just some specks of dust?
Well, if it was at a high enough concentration, it could be fatal.
Do you know how high of a concentration Mr. Armstrong inhaled?
What Mr. Armstrong inhaled wasn't diluted at all like the instructions say it should be. Instead, he was, in this diving mask, underwater, breathing in 99.6% pure acid.
Could you walk us through what kind of effect that would have on Mr. Armstrong?
Of course. As a matter of fact, I did actually bring along another visual aid to better explain the impact that this environment would have.
Permission to hand the witness a second visual aid.
Sure.
There you go, Doctor. What are we looking at here?
We can think of this hourglass like the confined environment created by Mr. Armstrong's diving mask. So on the bottom, there's the mask itself, which is where the acid was located, represented by this gray powder. And then up top is Mr. Armstrong's system.
How does this work exactly?
Well, actually, do you mind if I get a little bit closer so you can see better?
Sure.
So we can think of one breath in like flipping this hourglass. Alongside air, that acid from the mask is entering Mr. Armstrong's system and causing chemical burns along the way. If this were an open environment, we'd likely be looking at a single exposure. So still some symptoms, but nothing of the severity that we saw.
So why did we see such severe symptoms in Mr. Armstrong?
In this confined environment, as you can see, the acid and its fumes don't have the chance to dissipate in the same manner, which means that when he goes to take another breath, he's getting more oxalic acid. And this is something that went on over the course of about 15 minutes while he was underwater, where every time he breathed in, only increased his exposure to the chemical.
Thank you, Dr. Hartley. I'll take that back from you. And you can retake your seat. Do you know exactly what happened during those 15 minutes?
Yes, as a matter of fact, I do, thanks to that dive footage that I reviewed.
What did you see in that footage?
What confirms the findings of my autopsy because the symptoms I saw matched almost exactly what we would expect to see in a case of extended exposure to oxalic acid in this confined environment.
What were those symptoms?
When Mr. Armstrong first put on the mask, he coughed a little, but still entered the water. And everything seemed fine at first. That is, until he started appearing more and more confused. It started out simple enough, just struggling to untie some knots, but by around the 10-minute mark, he was just drifting, seemingly aimlessly around the course, sinking, surfacing at random.
What happened next?
Eventually, that disorientation just became so severe that he actually started tugging at his respirator and violently shaking his head until he successfully removed his mask. And at that point, it was mere seconds before the water entered his lungs. His whole body convulsed, and he fought one last time to reach the surface, but he drowned.
Thank you, Dr. Hartley. Thank you, Your Honor. Nothing further at this time.
Are you planning to use this demonstration?
No, Your Honor, we can use our exhibit.
Okay. Then just hand it back.
Your Honor.
Permission granted.
Good morning, Dr. Hartley. Now, just a few moments ago, you concluded that Mr. Armstrong drowned in acid, right?
Yes, that's right. Drowning with hypoxia was induced by that oxalic acid poisoning. That's right.
Exactly, it was induced by that oxalic acid poisoning. But Dr. Hartley, to be clear, you don't know if that oxalic acid was a part of the gameplay on the saboteurs.
No, I can't imagine why it would be.
That's because you didn't actually collect any evidence on the conditions of the show, did you?
On the conditions of the show? No, I was really focused in on the death and what caused it.
You didn't interview any players about Mr. Armstrong.
No, again, I was really focused in on the drowning and what caused that.
But doctor, in that investigation, you didn't even talk to the medical staff on set.
Objection, Your Honor. Rule 403 to substantially more prejudicial than probative. May I be heard?
Sure.
In calling Dr. Hartley's examination an investigation and asking repeated questions about what he didn't do on set of the saboteurs, this is misleading the jury into believing that Dr. Hartley's examination was insufficient. But he's a medical examiner and performed the autopsy in this case.
Response?
Yes, Your Honor. First, the bar for something being prejudicial or probative is substantially high. This line of questioning is simply explaining to the members of the jury Dr. Hartley's gaps in knowledge when it comes to the saboteurs specifically. As we've been contending since opening statements, we're not disagreeing with Dr. Hartley's conclusion, yet simply showing the lack of knowledge of the environment on the saboteurs.
I think he provided a lot on direct that went beyond the specific autopsy he did. He talked about the label, he talked about the environment, so I'm going to allow this questioning on cross.
Yes, sir.
Yes, sir.
Objection overruled.
So Dr. Hartley, I'll re-ask my question. You didn't talk to the medical staff on set of the saboteurs, did you?
No, I didn't.
The only person you talked to was a producer, isn't that right?
That's right, I did talk to the producer of the show in order to get a little bit of context about what occurred on set from somebody who was in charge.
Dr. Hartley, when you were talking to that producer, they were in police custody, right?
Yes, that was my understanding.
So to be clear, the only person you talked to about the conditions of Mr. Armstrong's death was someone being arrested?
Well, we didn't go too deep into the details. Like I said, they just filled me in on some of what happened from their perspective about how Mr. Armstrong was competing in this underwater diving challenge, and it seemed like they were the most relevant individual to talk to, regardless of whatever reason they may have been in police custody for.
But that's a yes to my question. The only person you talked to about the saboteurs and Mr. Armstrong was someone being arrested.
Objection, Your Honor. This question calls for speculation.
How so?
Just because someone is with the police does not necessarily mean that they are actually being arrested. Now, the witness clarified that in his previous response, but he cannot answer a yes or no to that question as he's being asked to speculate.
Was the producer in police custody?
This witness saw the producer with the police, but that does not mean that he necessarily knows whether she's actually being arrested.
Response?
Your Honor, if I may. I previously asked Dr. Hartley if the producer he was talking to was in police custody. He answered yes to my question. Police custody and arrested means the exact same thing, and is therefore it's in with his rationally based perception to make this, and there's no speculation being.
I don't think police custody and arrested means the exact same thing, but I'm going to allow you to question the witness, and he can answer as to whether he knew that the producer was in police custody, arrested, or merely talking to the police.
Yes, Your Honor.
Yes, Your Honor. So Dr. Hartley, the only person you talked to about Mr. Armstrong's conditions on his death was someone in police custody.
Yes, that's right.
And now I want to talk about that oxalic acid that you mentioned on direct examination.
Of course.
Because doctor, you're pretty qualified in that area, right?
Yes, I've dealt with a lot of cases that revolve around poisoning.
You've been a forensic pathologist for over a decade.
Yeah, coming up on 2.
Specialize in those rare toxins.
Yes, I've written some journal articles on them.
Doctor, you're being a little humble here. You actually created the protocol this entire county uses for identifying those rare toxins.
Yeah, that's right, actually.
So you know exactly how oxalic acid affects the human body.
Yes, I did.
Safe to say you know more than the average person.
I would hope so.
Now, I want to talk about what somebody would know without all your medical expertise. Because you reviewed a label in your investigation, right?
Yes, that's right, I did.
Let the permission to approach opposing witness in the bench with previously entered as Exhibit 13.
Granted.
You are perfect.
We have a copy.
Yes, Your Honor. Dr. Ridley, this is the label you reviewed in your investigation?
Yes, it is.
And Dr. Hartley just did have a demonstration of this label a couple minutes ago, right?
That's right.
But I just want to be clear, in real life, that label wouldn't be 2 feet tall, right?
No, it wouldn't be.
And if somebody were to pick up a bottle of oxalic acid, they'd see this label, right?
I would hope so. It seems pretty flashy.
Exactly. If they would see some bright colors.
Yes, they certainly would.
They'd see a heart on the eye of oxalic acid.
Yeah, I'm not sure what the graphic designer was doing there, but yes.
But Dr. Hartley, nowhere on this label does it say oxalic acid is a poison.
I would hope that that would be implied, but no, I don't think that word is explicitly used.
It doesn't say oxalic acid is poisonous.
Well, it says that it has symptoms which would be akin to any poison that I'm familiar with. Fatality, causing coughing, choking.
Now we'll get to those symptoms in a second, but it doesn't say the word poisonous on here, does it?
No, not that word explicitly.
And you said this bottle comes with a scoop, right?
Yes, it is supposed to come with a scoop.
Measures about 1 gram.
About that.
And doctor, you know from all your experience with oxalic acid that it takes about 1 gram of oxalic acid to cause medically dangerous side effects, right?
Yeah, anything over 1 gram would definitely be in the danger zone.
But that information is not on this label, right?
That information is not, no.
So when somebody were to read this label, they wouldn't know how many of those scoops it would cause any medically dangerous symptoms.
No, there's not a number on here of what would cause these symptoms, just that these symptoms would exist if people came into contact with the acid in this manner.
But that's a yes to my question. It doesn't say how much oxalic acid is needed for these symptoms.
No, it doesn't.
It doesn't even say how much of this oxalic acid would be needed to cause fatality.
No, just that it could be fatal at high concentrations.
But it doesn't even define what a high concentration even means.
No, but it says it's 99.6% pure.
So that's a yes to my question, Dr. Hartley. It doesn't say how many of those scoops would cause fatality.
A specific number of scoops? No, it doesn't say that.
Thank you, Dr. Hartley. No further questions at this time, Your Honor. Permission to retrieve the evidence.
Permission granted. Any redirect?
Yes, Your Honor. Let the record reflect I'm approaching opposing counsel with, once again, Exhibit 3. An approaching witness. May I proceed, Your Honor?
Yes.
Dr. Hartley, what warnings would a person see, even without your expertise, if they were to look at this label?
Well, it says that you should avoid breathing in dust or even mist, because that can cause those coughing, choking, chest pain, lung injury. You shouldn't get it in your eyes. Keep it away from your face in general. Avoid confined spaces, and certainly avoid repeated or prolonged exposure, because that can cause organ damage.
Thank you, Dr. Hartley. No further questions at this time.
Any recross?
No, Your Honor.
Alright, this witness is excused. Anything else before the state closes its case?
So, Your Honor, with that, the state rests its case adjourned.
Alright, anything else from the defense?
Not at this time, Your Honor. We're amenable to a recess.
Alright, let's take a 5-minute break. So we're gonna start back when that clock is at 11:20.
Yes, Your Honor.